Two orders that you issued yesterday, that is 13th of July. These orders are in respect of 3 applications, which perhaps because of time you'd consider at the same time in terms of our submissions, because they were all filed on the same day. That is miscellaneous application E162 of 2026, of 2026, which seeks the production of one Evans Otieno Omondi, we similarly have miscellaneous application E163 of 2026, the production of one Macmillan, and finally miscellaneous application E164 of 2026, Michael Olo Osoro. Olo Osoro. Your Lordship, upon consideration of the Chamber Summons applications dated 9th July 2026, you did certify them as urgent and summoned the first, second, third, and fifth respondents. The fifth respondent being the Inspector General of Police, Mr. Douglas Kajak, being sued in person, to appear before you today or by their duly appointed counsel, and similarly to produce the bodies of the subjects that we have mentioned, and or to show cause why the subjects should not be immediately released from their custody. Your Lordship, you directed that we appear before you at exactly 12 noon. Your Lordship, it's 12:27 from a reading on my clock, and we can confirm before this honorable court, because we have family members present, that neither or none of them, as earlier mentioned, have been produced before you today, which then would lead us to the second limb of your orders, that the respondents then should proceed to immediately show cause before this honorable court why the subjects should not be released from their custody. Your Lordship, in the applications, we explained the circumstances under which these Kenyans were disappeared, and we in our orders had asked that if indeed they're in their custody, then they should also produce before this court original warrants or orders that they have.
Authorizing their detention.
Yes, authorizing their detention.
Today was that the petitioners were to serve the directions and the application that is before you this afternoon on the respondents concerned. My Lord, I thought where my learned friend would have started his presentation would have been an assertion that indeed they complied with that direction.
I think he must have presumed because you are here. That answers the question.
No, my lord, it does not answer the question. The obligation, my lord, is placed on the petitioners, and it is for the petitioners to demonstrate that they have served. My lord, and it is my humble and respectful submission that the nature of the direction determines the nature of service. And my lord, with directions such as these that were issued at 5:30 or 5:25 p.m. yesterday, requiring attendance before you this afternoon, it is my submission that the only form of service that was proper is personal service. My lord, as I address you, it is my instruction that the orders have not been, the direction that you made on service has not been complied with. And my lord, my clients got to learn about these proceedings through the wide coverage that they received through the media. But that notwithstanding, my lord, we are here for the first, second, third, and fifth accused persons, pursuant to the directions made yesterday by your lordship.
Yes.
Your lordship is, in your own right, a leading criminal practitioner, and your lordship is familiar, more familiar than any of us before you this afternoon, with proceedings under Section 389 of the Criminal Procedure Code, otherwise known as habeas corpus proceedings. My lord, the structure of the chamber summons that has been filed by the petitioners and if your lordship will allow me just to demonstrate that briefly, is entirely ex parte. The application as framed and as conceived by the petitioners leaves no room for response by the respondents. My lord, the first prayer seeks, pending the inter partes hearing and determination of this application, a mandatory order of habeas corpus be issued directing the first respondent to have Evans, Otieno, or Mondi before this court or Mirimani duty court within 24 hours. That's an ex parte order. Again, number 3, pending the inter partes hearing and determination of this application, this honorable court be pleased to issue summons to the fifth respondent, Douglas Kanja Kirocho, being the oath holder of the first respondent, to appear before this honorable court. My lord, the fourth prayer, pending the inter partes hearing and determination of this application, a conservatory order hereby issue restraining the respondents, jointly or severally, from arresting, detaining, continuing to detain the subject with respect to any criminal proceeding. Lastly, my lord, upon presentation in court, an order be and is hereby issued to the respondents to unconditionally release the subject, and lastly, that the cost be provided for.
Yes.
By structure, it is ex parte.
Yes.
It seeks to achieve one purpose. It does not seek an explanation from the respondents. It seeks one purpose. It assumes that the subjects of the application are in the custody of the respondents. It does not give the respondents an opportunity to respond to those allegations. And my lord, it is then difficult to proceed as the petitioners or the applicants have invited your lordship to proceed. And my lord, I acknowledge that the court can only proceed as it is moved by parties. In an adversarial system of justice, The court listens as a disinterested arbiter between or to the submissions of contending parties, and thereafter makes a determination. The court cannot frame the complaint for the party moving the court. My Lord, having said that, in respect of the 3 applications before you, I am in court with the following officers. My Lord, the OC...
Let's go application by application.
My Lord, I believe in that matter the allegation is that a missing person report was made to Royal Police Station. Is it? 162? Yes. That the missing person report was made to Royal Police Station. My Lord, the OCS Royal Police Station is present. My Lord, in respect of 163, the allegation was that a missing person report was made to Madare Police Station. My Lord, I've just seen this one, so the OCS Madare is not here. And in respect of 164, the allegation was that a missing person report was made. The missing person report was made to Buruburu Police Station. My Lord, the OCS Buruburu Police Station is here. My Lord, we had misread 163 and understood it to also emanate from Buruburu Police Station, and that is why the relevant OCS is not here. My sincere apologies for that. My Lord, the also present in court is the Sub-County Criminal Investigation Officer for Buruburu. My Lord, that is where Roy and the Buruburu police stations fall. My Lord, also present is the Regional Criminal Investigation Officer for Nairobi. Yes, my Lord. My Lord, I had also indicated to court that Mr. Amos Omuga, who is Learned Counsel and the Director Legal for the National Police Service, is also present.
Mr. Omuga was here at 9.
And that demonstrates how seriously the National Police Service take this matter. My Lord, that is a demonstration of the seriousness that the respondents take this matter.
Yes.
My Lord, the first respondent and the second respondent in all 3 applications, and the 5th respondent, who is the same person as the first respondent, are not present. They are not present in person. And my Lord, the reason that they are not present is that they are involved in a meeting for planning for certain upcoming security operations, from which they were not able to excuse themselves given the shortness of the notice to to attend today's proceedings. My Lord, it is my request that the officers who are present then be allowed to carry out the role that the court wishes to be carried out in respect of these matters. And my Lord, if you still require the attendance of the first, second, and fifth respondents, I request that your Lordship assigns a date and a time when they can attend. And my Lord, lastly, without overemphasizing the point, the application before you in all three files is spent without, my Lord, there being an opportunity for the respondents before you to respond. My Lord, I request that you direct that this habeas corpus application proceed as all others do.
The rules dictate that an application for the issue of directions in the nature of habeas corpus shall be made in the first instance to a judge in chambers ex parte, supported by affidavit. Ex parte. So it is, the nature of this application is an ex parte chamber summon application.
Yes.
But more importantly, your Lordship, as to the nature and substance of your orders,
Yes.
the rules dictate that if the application is not dismissed ex parte, then the judge shall order a summons to be directed to the person in whose custody, the person alleged to be improperly detained is said to be,
Yes.
requiring his appearance in person or by advocate,
Yes.
together with the original of any warrant or order for the detention at a place and time named therein, to show cause why the person so detained should not be forthwith released.
Yes.
Your Lordship, if you read your orders and the application, they are in full compliance of those rules.
Yeah.
So those arguments should be dismissed. Your Lordship, applications in the nature of habeas corpus, writ, are orders as a matter of right by dint of Article 25 B and Article 51(2) of the Constitution, as well as Section 389 of the Criminal Procedure Code. And these are orders that ought to issue ex debito justitiae,
Yes.
as a matter of right. Your Lordship, Article 51(2) dictates.
Let's, Mr. Abduction.
Yes, Your Lordship.
Because we are dealing with preliminaries here.
Preliminaries.
There's something that Mr.
Yamod,
said,
yes, Your Lordship. I was
which I want
there.
you to address me on.
Yes, Your Lordship.
He says, the way you framed your application, they have no room to respond to the application.
Yes, Your
And you have
Lordship.
cited the rules.
Yes,
what
Your
they say.
Yes.
Now that they have confirmed they are not holding your clients,
Yes,
I
Your
think the best thing we can do is do the following: consolidate these applications.
Yes, Your Lordship.
Once we consolidate the applications, then I give you directions on how they are going to respond, because they must respond.
Yes, Your
You have made allegations against them, and they have to put something on record so that we can act on it. 3, I hear Mr. Nyamodi say that he has officers in court.
Yes,
We need
sir.
to agree Are we going to take viva voce evidence in this matter, or we are going to dispose it by way of affidavits? I think that will be the best way to proceed, unless any of you has a different view.
Yes, Your Lordship, we will go for viva voce evidence based on the nature and substance of the applications. Kenyans want to know where these 3 citizens are. And by the presence of 2 of the OCSs, Your Lordship, they are currently in court in compliance with your orders. Nothing stops them. For example, taking Doc today and explain to this court, because reports have already been made at their stations, missing person reports, as to their status of investigations, as to the whereabouts of the subjects. Finally, Your Lordship, before Mr. Oyo briefly submits, we are also cognizant of your orders, which remain alive and varied and enforceable by the court. And now that Mr. Nyamodi has indicated that the first and second respondents, first, second, and fifth respondents could not appear today in person, then we would be happy upon filing of responses that they appear before you subsequent to your summons to explain to Kenyans the whereabouts of the subjects, having failed to produce them before you today. Your Lordship, Mr. Oyo.
They can be given 3 days to come and tell Kenyans exactly where the missing persons are. Says, my Lord, have been too many. And this can be to come and shed light to Kenyans who are here, the parents who are here, who are not seeing their children, that if they say they do not have these people, then who?
Invite the court to look at, this is application number 164 of 2026, as the court considers to make its decision. We have certain circumstantial facts itemized.
Paragraphs.
This is paragraph 2
Of the affidavit.
as narrated by the certificate of agency, and I think captured also in the affidavit. The certificate of agency, paragraph 2, 3, 4, also captured in the affidavit of Pamela Allo. The disappearance of when Michael Olo require more than mere denial on the part of the respondents as duty bearers. So what they need to bring to court is either these missing persons, or to satisfy this court that indeed these persons who are responsible for the arrest and detention of these missing Kenyans are not members of the police service. That would be all.
Next question, which I want to respond to directly. It was directed at Mr. Mango, but I believe it is to all of us who represent parties here.
Yes.
My Lord, I believe that the way to proceed in this matter is, as the court suggests, for an opportunity to be provided for the respondents to respond to the applications, either as Mr. Ogada suggests or as otherwise. And once the responses are on record, then the hearing of the substantive habeas corpus proceed by viva voce evidence. Thereafter, my Lord, as I had stated whilst on my feet initially, the court can apply its judicial mind and make a judicial decision, depending on the veracity of the testimony that will be heard from the various parties as to what orders to make in this matter. my Lord, until such time.
Yes.
It is my suggestion that all parties should remain at liberty to continue to do their various tasks, complying with the court's directions for responses and hearing going forward. I'm most obliged. So as to prosecute the substantive habeas corpus application.
The presence of counsel for all the respondents is confirmation to the court that service of the application and orders of this court was done, or at least the respondents have knowledge of the same and are therefore duty-bound to abide by the orders. Thus, the issue of service to the respondents is closed. Number 2, the 3 applications, miscellaneous application number E, 162, 163, and 164, all of 2026, are hereby consolidated and shall be heard together. Number 3, the respondents, through counsel, having denied knowledge of the whereabouts of the subjects, and in particular stated that they do not have the subjects of the applications in their custody, they are hereby directed to file affidavits in response to the 3 applications by close of business on 17th of July 2026, as you had requested, Mr. Nyamodi. Taking into account the gravity of the matter and considering that counsel have indicated the desire to have the matters heard by way of viva voce evidence, the hearing of this matter shall be in open court on Monday, 20th July 2026. taking into account, that is number 5, taking into account the public interest element in this matter, the first, second, and 5th respondents are hereby directed to appear in person at the hearing of the application should issues arise that require their instant response. Number 6, hearing of the application shall be on 20th July 2026. The deponents of the affidavits in response to the applications are required to attend in person on 20th July at 10:30 a.m. So Monday 20th, let us meet here. We hear each side of the story.
My lord.
Yes. Sorry. On record.
Yes, my lord.
Who are you?
My name is Wasonga.
Wasonga
Joseph. Joseph Ouma.
Wasonga Joseph. You're an advocate?
I am.
Okay. Appearing for?
I am appearing for Macmillan.
That is in which application number?
163.
E163 2026. Yes.
I would like to bring some peculiar facts to your attention so that even at this preliminary stage, we can go the route of possible agglomeration. Your Honor, that is 163. However, we filed our habeas because I came as part of the independent medical legal unit. We are E159. Therefore, now that the conversation has shifted away from the point of simply having the matters mentioned and now being consolidated, the humble request to the bench would be that there be a consolidation of the E159.
We had
E159
application number 8 crying before me because of the fate of your relatives. But in fairness, when you come to court, have some faith that we are undertaking a process recognized by the law, and just give us that little room to do that which we can for you. So let us maintain some sense of decorum, and the way we conduct ourselves is so important so that everybody who walks out of here will walk out confident that they have been heard, they have been given the opportunity. So let's not make it very difficult for anyone, because I've just tried to imagine if we don't take charge of this process now, when we come to the hearing, it can be very nasty and we will not make any progress. So let's be fair to each other. When the matter comes up for hearing, we shall hear the applicants. You present your story and tell us what you know about this matter. Let the state also make their response, and then we'll give you a decision. But have faith that we shall do our duty. Okay? And I think that is good for everybody. Okay, thank you.
Evans alipotea tarehe 23 mwezi wa 6. Nimejaribu kutembea kwa hospitali, kwa mochari, kwa police station zote za Nairobi, sijamwahi mpata tena. Naomba serikali kama kuna mahali amefichwa, naomba wamtoe, aregee nyumbani.
Alipotelea tu Mathare ama Town ama?
Aliokotwa, alibebwa Ruai. Pikipiki yake ilipatikana Ruai police station, ikiwa alipigiwa simu na katoweka kaenda. Alikuwa mtu wa bodaboda.
Kwa majina naitwa Beatrice Wanjera, mama Macmillan Kierie, ambaye alitoweka mnamo tarehe 20 Jumamosi mwezi uliopita. Mimi ni mkaaji wa Mathare, lakini Kierie alitekwa nyara huko kijiji cha Kizito, Githurai. Alikuwa anakuja kwangu kwa sababu kazi zake ziko huku kwangu Mathare. Ni chairman wa football club inaitwa Shield Foundation. Ni kijana ambaye si muhalifu, ni kijana sio mwizi, ni kijana ambaye nimemlea na njia ya kanisa. Tumemtafuta kote, nimetembea mahospitalini, mochari, tumeenda hadi kwa DCI, tumeandika statement, tukaitwa bado hadi kwake, wakafungua mlango, wakajaribu kumtafutia makosa, hakuna chochote walipata. Sasa tunauliza serikali yetu, President William Samoei Ruto, Kanja, Murkomen, tafadhali mtusaidie. Sisi ni Wakenya, tunataka haki yetu. Hawa vijana mahali waliko, tafadhali muweze kutusaidia. Tunajua ya kwamba ni nchi yetu ya Kenya, lakini ikifika kama wakati huu tunalia kama wazazi. Jiwekeni nyinyi wenyewe katika hizi viatu zetu. Siku 25 leo zimeisha bila kuona mtoto wangu. Wengine hapa tunatumia madawa za pressure. Jameni, mtuonee huruma. Hawana hatia, na kama mliona hatia mngewapeleka kotini. Sisi tunajua kusamehe kwa sababu tunajua Mungu ni mweza yote. Mungu atawaonekania. Tafadhali popote vijana wetu waliko, hata kama sio polisi, hata kama ni kwa kichaka, leo hii tuonyeshani pali watoto wetu wako. Tutashukuru. Hatutarudi hapa kotini tena. Tunajua ya kwamba Mungu ndio anajua kujaji. Sisi tutawasamehe. Tukipata watoto wetu, hatuna mambo mengi. Tumejaribu kuomba, tumeomba kabisa, na yote tunaachia Mungu. Pia nyinyi mliumbwa na Mungu. Tafadhali tuleteeni watoto wetu. Tunajua wako hai, hawajakufa. Mungu atawasaidia muweze kurejesha watoto wetu, na Mungu atawabariki, na pia hayo makosa yote tutawasamehe na tutaweza kusahau. Tafadhali mtusaidie, na tunawaomba kwa hisani yetu. Kuanzia leo tusilie tena. Tafadhali sikia ombi letu kama sisi ni wananchi wa Kenya ambao tulikuchagua na roho moja bila pingamizi. Tunakulilia tukikuomba Roho Mtakatifu aweze kukushukia mahali wewe ulipo, na pia wale walioteka hawa watoto nyara. Tunawaomba kwa sababu mnatuona. Shetani mbaya tunamuomba aweze, tunamkemea katika jina la Yesu. Tunajua tumeteseka hizo siku zote. Mmoja alitekwa nyara tarehe 19, Kearie wangu tarehe 20, huyu mwingine tarehe 23. Woi, hatujui wanakula nini, hatujui wanalala wapi. Sisi wenyewe tuko na mawazo, wao wenyewe wako na mawazo. Simu zao zilizimwa, hawajui waongee na nani. Tunajua wameomba ya kutosha, na pia nyinyi labda mmewahoji ya kutosha. Tafadhali serikali, tukianzia na President William Ruto, naomba Murkomen, watoto wetu mtupe, watoto wetu, Mungu aonekanie, na Mtakatifu awashukie. Turudishieni Kearie, turudishieni Abbas, turudishieni Michael, hizo na watu pia wale wana maombezi. Mungu awasaidie leo hii tupate watoto wetu. Asanteni, na wananchi wote wa Kenya, pali tasikia watoto wetu wako. Tafadhali utusaidie. Nashukuru.
Jina naitwa Rosapi, wife to Michael Olo Osura. It's now 3 weeks 4 days. Alichukuliwa date 19 kwa kinyozi ya kinyolewa. It's so painful, so heartbreaking. We have knocked many doors. Saizi ni end month, bills need to be paid. We need to pay rent, we need to pay school fees, we need to buy food. But instead of me looking for money, natembea nikiwa DCI, Buruburu Police Station, Milimani Law Court. Hizi bills zote zitalipwa na nani? Saa zile mimi nazunguka nikitafuta mtu mkubwa mwenye serikali inajua mali yako. It's so heartbreaking. Tumekunywa dawa za roho. I am tired. My 3 years boy, ule mdogo, every day anakuuliza, "Mami, where is daddy?" It's so heartbreaking. Alichukuliwa Umoja 1 Charina kwa kinyozi ya kinyolewa.
Leo umehudhuria vikao vya mahakama. Ulikuwa ukitarajia nini?
Mimi leo nilikuwa ninakuja nikijua I'm going to come out with my husband, ama nijue ako wapi. But now I know through this process, God has the final says. God has the final says. Alikuwa mwenye duka, alikuwa na duka at Mathare. Biashara yake ilikuwa Mathare. That's why tumereport like police stations zote Mathare, tumereport Buruburu, everywhere. It's so painful. Ruto, uliuliza hii kiti na tukakupea. Government inasema vizuri, inajua mali tunalala, inajua mali tunaamka. See this pain. So at
You can speak.
Let Nerima say.
Nerima, you can wind up.
Yeah, just
We are here today, as you have seen the devastation with these families. What country do we live in when people are picked up for over 20 days and we have a constitution, we have laws? If you wanted to question them, you can, there's due process. But we cannot accept where we are seeing citizens, young men, being picked and disappear. When you hear the police say that they don't have them and they don't know where they are, as our protections, they need to tell us where exactly they are, because they are to keep us safe. They surveil us all the time. It is our right to live freely. However, when you have people with balaclavas picking people up and you can't tell us where they have gone, then who are these individuals who are gallivanting our cities and terrorizing our families and terrorizing our children? It is a sad state of affairs. Every citizen in this country needs to be concerned because we have a constitution that is to protect us. We cannot live in a country where people are picked up and disappear. We need to see them, we need to know where they are, and they need to be safe. And this case will continue. Our legal representatives, the next mentioned date is going to be on the 20th, and the individuals who are in the authority to be able to answer these questions will be summoned to be present. Thank you.
Nerima, the High Court judge did mention that you have faith in the process that is currently ongoing. Do you have faith in the process? Summons were issued for him to appear.
Faith needs to be seen.
I have faith, but like my colleague has said, faith comes with action. So we are here. We are using the legal processes to do this. We are going to rely on the courts to give us a response. We are glad that these processes are public. It's going to be in front of the Kenyan people. A lot of questions do need to be answered. People need to be held accountable. And we need to know where these young men are. I will have faith for now. And so we'll see with the process as it continues whether we will get the answers that we deserve.